evening to all our guests who are joining us, the Psychedelic Association of Canada's webinar, and to all our American guests, happy Thanksgiving. I'm Gillian Maxwell, and I'm a founding member of the Psychedelic Association, which was born on December 31st, 2019. And we work to gain access to psychedelic and plant medicines for all Canadians. We work at many levels, engaging policymakers and politicians, creating and bringing together communities across Canada. We brought together several dynamic groups within the association so they can contact with each other and connect, such as doctors and therapists, nurses, harm reduction workers, and businesses. Please join us, become a member, psychedelicassociation.net, so that we speak with a strong, united voice to establish access to psychedelics in Canada. We are a lean machine operationally. We are a nonprofit organization that relies on grants and donations to keep the lights on. And our 1.5 staff and many outstanding volunteers give their all, and thank you to all of you. Although I'm not there right now, I'm usually based in Vancouver, British Columbia, and I acknowledge that we live, work, and play on the traditionally shared, unceded ancestral territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I'm delighted to introduce to you our courtroom panel today. I'm going to do introductions of our three panelists, and then I'm going to hand it over for them to take you through this very, very interesting conversation. First of all, John Conroy. He's a barrister and solicitor based in Abbotsford, BC, and has his own law firm, Conroy and Company. His practice is primarily as defense counsel in criminal matters, with an additional focus on sentencing and post-sentencing matters, which involves an extensive administrative law and constitutional law practice. He has received many awards, and which include, for his advocacy work, which include the International Society for the Reform of Criminal Law, and his many and significant contributions to Canada and his fellow Canadians. John is Queen's Counsel, which of course is now the King's Counsel, and he received the Queen's Diamond Jubilee Medal in 2012. He has an outstanding record and commitment to making the lives of Canadians better by using the laws that exist and making the case for change. He's been involved in numerous cannabis cases since 1972 and incorporated the National Organization for the Reform of Marijuana Laws in Canada, Normal Canada, in 1977, the BC Compassion Club Society in 1997, and was counsel to numerous well-known members in the cannabis community. He was lead counsel in the Allard versus Canada case that determined the previous medical marijuana regulations to be unconstitutional and led the way for access to medical cannabis and then legalization under the Cannabis Act 2018 pertaining to medical use. He has appeared on these issues before various parliamentary and Senate committees. He also appeared as counsel in the Supreme Court on behalf of the Vancouver Area Network of Drug Users, VANDU, that preserved Insight, Vancouver's supervised injection site, by establishing that it is indeed a health facility. Welcome, John, and thank you for agreeing to be our moderator today. Spencer Hawkswell was first introduced to healing the psychological trauma with altered states of consciousness and therapeutic psychedelics from reading the work of Terence McKenna, Rick Strassman, and Carl Jung, and believes that these methods need to be treated seriously by governments and institutions. Spencer believes that responsible drug policy requires effective organization and leadership, and is dedicated to bringing together the experts and advocates to facilitate change that results in increased access to compassionate care, harm reduction, and treatment options for those in need. Psilocybin-assisted psychotherapy is a reasonable treatment option for palliative patients in end-of-life distress, and is where we need to begin. Paul Lewin is a lawyer. Welcome, Spencer, and thank you very much for being here. Paul Lewin is a lawyer in Toronto who has argued drug cases across Canada for 28 years. He practices with Lewin and Segarra and Cannabis and Psychedelics and the Cannabis and Psychedelics Law Group. His focus concerns litigation and consultation on matters regarding cannabis and psychedelics. Paul has advised patients, doctors, medical professionals, businesses, politicians, teachers, lawyers, and the police on cannabis and the psychedelic law and policy in Canada. He has spoken at numerous cannabis and psychedelic events, lectured at universities, and has been interviewed dozens of times in the media on cannabis and psychedelic law and policy. Paul has litigated the constitutionality of the cannabis regulations in various courts and provinces. Paul was lead counsel on Dr. Bruce Tobin's 56 exemption psilocybin application. Paul was on the board of the directors of the National Organization for the Reform of Marijuana Laws, NORML, and advocates for cannabis reform which advocates for cannabis reform from 2011 to 2020. He spearheaded advocacy campaigns across the country and lobbied politicians at all levels of government. Paul is currently in federal court challenging the constitutionality of the psilocybin medical exemptions in Hardle versus His Majesty the King. Welcome, Paul. So we are about to begin our conversation about taking the government of Canada to court to help people with end-of-life distress. And so I'm going to hand it over now to all of you and my esteemed friend and colleague here, John Conroy. Please take it away, and I'm here to hold space for you. And as I told you earlier, if you get a little bit carried away in all your, legalese stuff, I might go, what did that mean? But please take it over and have some fun, and let's make something happen. Let's change the world.
Well, thank you very much. As you said, I've been practicing since '72, so it's my 50 years in now. And I'm coming to you from just east of Mission, British Columbia, where I've lived since '73. And the topic being psilocybin, it's interesting how attitudes towards different forms of intoxicants or drugs, as they like to call them, have passed over the years. But I can look out at a field out my window here, and psilocybin used to grow around on the farm. And I remember a period of time when we were told that it was people from Montreal in particular, from Quebec, that were coming here, and they were going through all the farmers' fields and disturbing the cows, and farmers were upset, and they were packaging the psilocybin and getting it back and selling it for a huge price in Montreal. And this would have been mid to late '70s, maybe early '80s. And so I was telling Paul earlier, I went to a Canadian Bar Association meeting, and I said, look, I know what these things are. They're growing here in the field. I know what they are. I have control over them. I'm in possession of them. What should I do? Do I have to run out there and smash them over the head in order to stop them from growing, or what? Needless to say, I didn't get any good advice from anybody as to what to do. But those were some of my early experiences with psilocybin. And just a clarification, it was really the Parker case, Alan Young and Aaron Harnett and a number of lawyers in Ontario and Toronto who really made the change, forced the government to change the cannabis laws. And it was the Allard case was only after first Parker had forced them to come up with the medical marijuana access regs, and then Harper came in wanting to take away people's right to grow for themselves or have somebody grow for them with the medical marijuana purposes regs, if I get the titles right, and ultimately to the access to cannabis for medical purposes regs. Those are the sort of the history. And so the Parker case, which I'm sure Paul will discuss to some extent, is a pretty critical, and it used Section 56. Was an issue when the court found it was unconstitutional. But then years later, as you pointed out, when I was in Vandu, on for Vandu in PHS, the supervised injection site, which was, unlike Parker, who was charged criminally and raised the charter defense and the necessity defense, the PHS was an application where they had a Section 56, and Harper was going to close it down, and it was about keeping it open. And so it was to compel them to use 56 to carry on and keep it open. Although for Van Du, I was also challenging the law in a broader way. But ultimately, the court used Section 56 to keep it open. And so I think that's going to be the Parker case and the PHS are very interesting cases for purposes of our discussion here. So,
thank you, John. And I just wanted to ask all of you, at some point, there will be somebody sitting here wondering what Section 56 means. And probably you'll be saying SAP or SAP at some point. So both of those, just a quick.
I was going to. Yeah, Section 56 is basically a provision in the Controlled Drugs and Substances Act that gives the minister a broad discretion to exempt people from the law for scientific or medical purposes or otherwise in the public interest. And so that's what was used in terms of the supervised injection site. And it was raised in Parker as an excuse to say, well, the law is valid because the minister can always give you an exemption. Whereas, as I say, in PHS, it was using it to compel them to prevent people's constitutional rights from being violated. And so here, a distinction, of course, between the cannabis stuff and what we're doing now is cannabis was a narcotic under the narcotic control regulations that became regulations under the Controlled Drugs and Substances Act, and happened to have a provision where a practitioner, which was broadly defined, could give, sell, administer, or prescribe any narcotic to a patient for a medical condition they were treating them for. Psilocybin, on the other hand, wasn't a narcotic. It was Food and Drugs Act. And while Food and Drugs Act 2 regulations get carried forward into the Controlled Drugs and Substances Act, and so the prohibitions were in the Controlled Drugs and Substances Act, there was no food and drug regulation allowing doctors to prescribe in the way there was under the Narcotic Control Act. So a big difference between what cannabis and what healthcare practitioners could do in terms of cannabis compared to the problems that I'm sure Paul will get into in greater detail. But it is an offense under the Controlled Drugs and Substances Act to possess psilocybin, to traffic in it, to possess it for the purpose of trafficking, to produce it or cultivate it, to import it or export it. But the penalties are maximum 3 years on indictment, so quite different to the penalties that we were facing with cannabis and some of the certainly some of the other drugs. So I don't know. Hopefully that puts it into a context where we're now focused on psilocybin mushrooms under the Food and Drugs Act, and you have patients like Mr. Parker in the cannabis case who needed cannabis supported by his healthcare practitioners, was helping stop his convulsions from his epilepsy. And his doctor supported him. Now, I haven't been able to, I was trying to figure out whether his doctor had actually written him a prescription under the narcotic control regs, but I'm not sure he did. But so an issue may be for discussion is if we have healthcare practitioners here who support that these people are suffering and their access for medical treatment is being reduced and unfairly limited in violation of their charter rights. We may have there's a similar parallel to what was going on with the cannabis cases, but the penalties here at least are far less if somebody's engaged in producing it for themselves, and would presumably, if busted, argue Section 7 and necessity, that the evil they're committing is a lesser evil than the greater evil of what may happen to them because of their health and so on. So hopefully that gives you a bit of a framework of some of the issues that we've been dealing with on over the years. And let me turn it over to Spencer to tell us exactly how this litigation is coming and the background and history for it.
Thank you very much, John. So I work with Therapsil, and the whole idea behind Therapsil was to support Canadians who, at the time, our founder, Bruce Tobin, knew had the same constitutional right to psilocybin. The Canadian drug law, and quite frankly, the precedent that's been set by some of these cases, such as the ones that you were involved with, both John and Paul, really put us on the shoulders of giants here in Canada. We know that Canadians have the right to psilocybin. It's not something that that the doctor or patients felt that they had to guess. So really, we had this playbook in front of us. And the playbook was, you ask the Minister of Health for Section 56. And if they deny that access, quite frankly, even if they grant it, there is a court case here. And sometimes the best way to start exposing all of the problems with these Section 56s or SAPs, which is the Special Access Program, another regulatory approach to getting patients psilocybin, sometimes you have to exercise them first. So we decided as an organization, we would do absolutely everything we could to change the drug laws in Canada. And as it said in my bio there, we decided to start with the palliative patients, because here was a group of Canadians who, after the Carter case, might not be the Carter case, but after the medical assistance in dying changes, they were allowed to use MAID. They were allowed to end their life. And in effect, that meant they were allowed to access a drug that was going to stop their heart. So why wouldn't they be allowed to use psilocybin? And I think that this is something that most Canadians really, really understood and agreed with. We ran some polls, and it was an overwhelming landslide support for these Canadians who wanted access to psilocybin before having to choose medical assistance in dying. I mean, even just the research alone, if we had not had MAID, was very, very compelling. Something like 80% of patients seeing clinically significant decreases in their end-of-life anxiety and depression after a single dose. This was all happening too in about 2019, 2020, right when COVID came around. So seeing those sorts of results from clinical trials, if this had been COVID, well, we would have been jumping all over that, trying to get people access as soon as possible. But that's what happens when there's an emergency and when someone who's vulnerable needs access to a substance. It's why we fast-track vaccines for people who are actually in their same position. And so that led us down, this whole exercise led us down a road to asking the Minister of Health for access. And after being denied for a couple of months, we worked with Paul Lewin here, who started the constitutional challenge. Paul, I think we were about to launch that constitutional challenge when the Minister of Health at the time, Patty Hajdu, actually granted the exemptions, which might have thrown the court case off for a little while, but did get some patients access. I think what we'll come to find is that actually strengthened the evidence that we have, because over the next year, we went on to help about 55 other Canadians, palliative Canadians, and also those without palliative diagnoses, such as treatment-resistant depression, get access to psilocybin, and it worked for them. We also helped 19 healthcare practitioners get access to psilocybin for training purposes so that they could use it, making a similar argument to what we had made for the patients, and a similar argument that's been made in the past for access to other substances for training, and that is no therapist does any psychotherapy without being subject to that therapy first. And that's, internal family systems, cognitive behavioral therapy, even massage therapy and hypnotherapy. You're always subjected to it first so that you can understand it before you actually go and practice that therapy. And the minister, a compassionate woman, Patty Hajdu, she granted those exemptions too. So now we have the situation where there are two classes of Canadians, those who get access to psilocybin through Section 56 and those who don't. And when the new ministers of health, Jean-Yves Duclos and Caroline Bennett, came into power, they decided not to grant any more Section 56s, to move to the SAP. And so these patients and healthcare practitioners were really just saying, well, why are some people allowed this emergency and life-affirming medicine while others aren't? Why do Thomas and Lori get access as patients, yet I'm left standing in the dark, in the cold? Why do some therapists get access and we don't? And for the patients, I'm sure that people can understand this. Imagine having a medicine just near cure your anxiety and depression, and then have it taken away from you. That is not just, it's not just unconstitutional, it's cruel. And so we started lobbying for these patients and started a court case with the help of well, really, Paul Lewin started the court case with the help of us and many of these patients. And he's got an excellent legal team, and I'm sure we'll be passing it over to him in just a moment here. And he's been helping these patients launch a constitutional challenge that is aimed at saying at striking down these laws of prohibition and putting in their place regulations that are reasonable, timely, and effective, and help patients get access to psilocybin. It's really as if, our Canadian government suffers from amnesia. They don't remember what happened in Carter. They don't remember what happened in Parker. They don't remember what happened in all of these amazing cases around abortion, safe injection, medical cannabis, medical assistance in dying, prostitution, where Canadians' Section 7 rights affirmed them access to the medicines or the care that they were getting, or that were helpful for them, and that their doctors believed would be helpful for them. So the fact that our politicians are ignoring this really just points to a few things. And one might be they're paying no attention to it at all, which would be very tragic, given that these patients are quite literally in a life and death situation. And the other one would be that they're too afraid and that they lack the courage. And I know it's difficult to find a courageous minister. We certainly had one with Patty Hyju. But in Canada, we need that sort of courage when patients are backed into corners where their only options are medical assistance in dying, or where our government is telling them that they need to try electroconvulsive therapy before they can access psilocybin. A gentleman on the one of the plaintiffs of the case, he's used psilocybin to get off his heroin addiction as well. And we made many requests for Section 56. We even made requests to the BC Minister of Mental Health and Addiction, Sheila Malcolmson, to get help and support approving this. And the unfortunate thing is, when we look at the context of what these patients are being provided instead, what we're seeing is that they're being ignored here simultaneously, or at the same time, MAID is being expanded, and these patients are being, given exemptions to use their drugs of addiction, such as heroin, through the Section 56 that Sheila Malcolmson requested. They're being ignored on the Section 56 for mushrooms. And I'm in no way against that Section 56 for safe supply or decriminalization for hard drugs. That's excellent. But we need to do more. We need to help these people get access to the medicines that are healing them and helping them. So I really believe that these patients have a case. And before I blabber on for too long, because I'm sure we'll have lots of time to talk back and forth, I want to pass it over to Paul Lewin to talk about the case he's building and where he's at there.
Just before we go to Paul, do we have the refusal on the part of these ministers to grant Section 56s? Do we have that in writing? Do we have it documented evidence? Because that really flies in the face of the Section 56 issue that arises in the cases. So is that part of the record? Do we have that?
And Paul, I might need you to help jog my memory here, because I should certainly know this. I know we have the intention to refuse for some patients. I know that we have the refusals for healthcare practitioners, but Paul, am I correct in saying that we haven't actually received a refusal for patients yet, or did we actually receive some of those?
Well, I believe Mr. Merckx was refused. I noticed actually one of the questions earlier on was, how long does it take to get a Section 56 exemption? And the patients have faced ridiculous delays, 8, 10, 12 months. Some of these people are, they're facing end of life. They don't have 8, 10, 12 months. It's disrespectful. It's profoundly lacking in compassion and perspective. It's wrong from so many different standpoints. So how long does it take? It can take a while. So it could be a lot shorter, but there's horrible delays. And that's even if it's not a refusal, even if it's someone has to sit waiting 10 months for treatment and suffering for 10 months, that's not appropriate.
No, but have those ministers in a press conference or in a particular file specifically said, we're not issuing Section 56s anymore, go for the special access program? Or, is there an official government position on no more 56s and no more SAPs for groups.
So what they've been saying since early in 2022, they started saying there's going to be no more Section 56, or they didn't say no more Section 56s. They encouraged everyone to apply for under the SAP.
When you say
special access
they,
program.
when you say they, do we have an actual official from the Ministry of Health that we can quote?
This isn't, oh, sorry, Spencer, go ahead.
We do. We have Jennifer Sachs, the director there,
Okay.
who has encouraged everybody, as well as Carol Ann Chenard and many of the different people within Health Canada who have said that, you know, and here's their exact language too, is we encourage people to explore clinical trials as the first route. After that, we still have SAP and Section 56 on compassionate grounds that will be, you know, reviewed on a case-by-case basis. So they haven't shut it down. But I would say that as far as I can tell, it has been shut down. We haven't received a single one, and there have been many, many patients who have absolutely failed clinical trials and the SAP route. So Section 56 is their only option left, and they've been ignored.
Okay. We'll probably get into that in a little more detail in terms of what that means based on PHS, but let's go over to Paul, and he can take it away.
Thank you, John. And actually, just before I jump into things, I just saw a comment on the screen about without a refusal, we need a mandamus application, and going to bringing any form of judicial review is a great idea. And in fact, just before we came on, we were all discussing the idea of different types of judicial reviews that we could bring. But what this constitutional challenge seeks to do is we're saying this whole idea of having to go to the government, apply to the minister, put together a large package of information, reveal a lot of private, intimate details about yourself and send them off to the government, and then wait and then maybe begin a dialogue with the government about why your suffering is worthy of trying this treatment, explaining all the different things you've tried. We're saying that's not acceptable. That's not reasonable access. And that's the test. Some people say, well, what is the test that you have to meet? And happily, during the cannabis wars, there was so much court fighting that really the test is to access in this situation, someone facing a serious health issue. What is the test that we have to meet? What does the government have to do? They have to provide reasonable access to psilocybin. That's what they have to meet. And that's well-established law. John here is a big part of that. We can thank John for that. Very good standard. And what there is, and another question a little earlier on was, what's the legal status of psilocybin? Well, it's prohibited. It's prohibited. You can't possess it. You can't sell it. You can't grow it. You can't bring it into the country or send it out of the country, except if you fall into one of these exemptions, the Section 56, the special access program, or you use it through a clinical trial. And these don't provide reasonable access. And that's really what the test that we have to meet. So I guess you could say there are medical exemptions, but they're terrible medical exemptions that are being doled out with an eyedropper. So anyway, I'll start by...
And one of them too, as I understand it, just so that's clear, is while some of the patients got a Section 56, it didn't include the right to grow their own. So the source of supply is still another issue.
Yes, actually, thank you, John. So patients have the right to possess it. And we have a mycologist, the great Paul Stamets is going to be one of our witnesses. And he says it's unsafe to pick psilocybin in the wild unless you're a mycologist. You could poison yourself. So it's not safe to pick it. Presumably the government knows that. No one can give it to you. You're not allowed to grow it. So I'm guessing that you have to walk around, unless it falls out of the sky and lands in your hand, you're engaging with the black market. And the Hitzig decision, which I'm sure John knows well, the Ontario Court of Appeal, they tried this in cannabis context. They were saying, well, why don't you look to the black market? And the Court of Appeal just was not, did not take kindly to that suggestion. And they really gave the government a good dressing down on this idea that the government is in cahoots with the black market, saying, well, why don't you go there? And that's essentially what these Section 56s all were, is telling patients to go to the black market, and we won't walk, we'll look the other way while you do that. So Yeah, no, that's a horrible flaw with the Section 56s. So I'll just give you a little bit of background. Actually, I just see on the screen here, will the pharmaceutical industry influence the psilocybin, the ability to access it? And probably, but that's the beauty of going to the court. That's the beauty of the Charter of Rights and Freedoms, that we really have a terrific tool in Canada to bring about positive change in the drug context. It's something that the Americans have their ballot initiatives, but we've got the Charter. And the amazing things were done in the cannabis context with the Charter. And we're going to do the same thing with psilocybin. So this case, we're in federal court, and there's 8 plaintiffs, 8 bold, brave people who have stepped forward and are at the face of this challenge. 7 of them are patients. 1 is a healthcare professional who seeks access to psilocybin to be properly trained. There's 6 lawyers on the team. So we're already in federal court, and we've been dealing with various procedural matters with the judge. I'm going to talk about the 3 main issues in the case. I'm then going to talk a bit about the evidence that's going to be called. And then I'm going to finish off by talking a little bit about what we're seeking and how I think this is going to play out. So in terms of the 3 main issues, probably without a doubt, the first big issue in this case is that we say a constitutionally compliant means of access requires doctor as gatekeeper access. This is a decision that must be between patient and doctor, is what we say. It cannot be government as gatekeeper or government bureaucrat as gatekeeper, as it is under Section 56 and the Special Access Program. Both of those systems have, the legislation states that the government may grant an exemption or may grant an authorization. And so the government isn't obliged to do anything in either situation when you apply. The government, this is truly unfettered discretion. They can do whatever they want, and they can refuse you for reasons unrelated to your health. And so we say that that's not reasonable access. That this will fail patients. And as well, the government also directs people to clinical trials. And if your clinical trials are not a reasonable means of access, there's no, when you need it, you go and consult with your doctor. You don't hope that there's a clinical trial near you. You don't hope that the clinical trial is going to begin soon and that you're eligible for it, and the clinical trial is properly geared towards your issues. It's not a suitable means of seeking access. Access to drugs must be the same way that we access all other drugs, including opioids and amphetamines and benzodiazepines. You could meet far more dangerous drugs. You meet with your doctor, and between you and your doctor, you decide what's best. That's doctor as gatekeeper access. And before I go on about that, I want to note too, some may be thinking, well, psilocybin doesn't have a drug identification number. How could we possibly do that? They did it with cannabis. In cannabis, there's something called a medical document, and we can call it what you want. It's a piece of paper where the doctor authorizes your access. And that's what we're saying. Whether it's got a drug identification number or not, it doesn't matter. There's many patients suffering a lot. This is a terrific drug that's very safe and has amazing results. So there's no stumbling blocks here. It's very doable, but the decision-making process is between patient and doctor. It's doctor as gatekeeper. And I say doctor, the doctor is the only suitable gatekeeper because the doctor is best able to determine the patient's access for many reasons. The patient's doctor is best placed to determine the proper course of treatment because they're much closer to the patient and they understand the patient's needs, as opposed to the government. The patient's doctor knows the patient's medical history, the severity of the health issues, the treatments that have been tried, and perhaps most importantly, the suffering the patient's going through. The patient's doctors are the ideal gatekeepers because they have a commitment to the patient's well-being, a legal commitment. The government does not have a legal commitment to the patient's well-being. Doctors have a duty to consider first the well-being of the patient, always act to the benefit of the patient, and promote the good of the patient. And I submit the ideal gatekeeper must be wholly committed to the patient's best interest. To make anybody else the gatekeeper would be to discount the interests, the best interests of the patient. Doctors are the ideal gatekeepers because such an approach is more consistent with the doctrine of informed consent. The doctrine of informed consent establishes the patient's right to make meaningful decisions about medical treatment. Informed consent is rooted in the concepts of an individual's right to bodily integrity and respect for patient autonomy. This is a medical ethics issue. Informed consent is a basic accepted legal principle that, according to the Supreme Court of Canada, every human being of adult years and of sound mind has the right to determine what shall be done with his or her own body. Doctors are the ideal gatekeepers because they're trained in and mandated to provide patient-centered care. And I'm going to talk a little bit about that further along. Patient-centered care puts the patient first. Patients should play a central role in decision-making. This is not patient-centered care, what we have going on here. And of course, the government, they don't have an obligation to act in the best interest of the patient. They don't have a duty to the patient. This is not, Section 56 and the SAP are not reasonable access, do not constitute reasonable access. And I mentioned earlier that they may grant a 56, that's the legal test, or a SAP authorization. But if they don't, what happens for these patients in vulnerable health and often of modest means? Well, they have to hire a lawyer and embark upon complex, expensive litigation in which they take the government to court, federal court, to bring a judicial review, have the decision reviewed. And that's not reasonable access. Patients shouldn't have to go through this. You shouldn't have to hire a lawyer. You shouldn't have to have medical experts on your team to show why the government was wrong. So, so we're going to change that so that in the future, it's a decision between patient and doctor. And we think that's going to be huge. That's going to be a game changer. The second big issue is that therapist access to psilocybin for training purposes. And this is necessary for safety and therapeutic reasons. Healthcare professionals who use psilocybin to train in the administration of psilocybin-assisted psychotherapy are able to provide safer and more effective treatment. If we're going to create a regime where patients can access this medicine, then we have to have properly trained therapists. And these therapists have to have access to this drug. And this is a matter of trust. The patients don't, if the therapists don't know what the patients are going through, you're not going to have that trust. They have to understand what the patients are going through. It's a unique type of medicine. It's a unique type of experience. And as well, there's not enough healthcare professionals who have had this proper legal training. Healthcare professionals should not have to go to the black market to get this. They shouldn't have to travel to other countries to get this. They should be able to legally access it. We should be making it easy for them to get access so that patients can be better trained. When we're starving the healthcare professionals from getting proper training, we're ultimately hurting the patients. This issue about healthcare professionals, this is a patient issue, is what this is really about. And Therapsil have done amazing work. They 19 healthcare professionals obtained Section 56 exemptions in order to obtain proper training, and then the government cut off the tap arbitrarily. And there have been 96 refusals. Maybe there's more since I last reviewed this. And one of the lawyers on the team, Nicholas Pope, has taken the government to court and sought judicial review of those refusals. But we're raising this as well, that we want to change the whole system so that nobody has to hire a lawyer and go to court. The third big issue is patient access to natural psilocybin mushrooms and synthetic psilocybin. And what we set out to do in this case is we wanted to give maximum choice to the patients. This should be all patient-driven. And for some patients, they really like the fact that they're getting a regulated product. And I think many patients would like the idea of synthetic psilocybin that they're obtaining from a company that's following various regulations. They like that, and we understand that, and that's suitable for many. For others, they've had positive experiences with natural psilocybin mushrooms. They don't want to try something new. They want to do what's worked before. And so Mr. Paul Stamets told me that 99% of psilocybin experiences in the world have taken place with natural psilocybin mushrooms. So we'd like people to be able to access natural psilocybin mushrooms. It's my understanding, and this is getting a little deep into the science, so we have others on the team who know this stuff better, but that there's just no way under a special access program that you're going to get access to natural psilocybin mushrooms. And as well, we want, and this is something that was raised in the cannabis context, some people want to grow their own. It's something that they find by growing their own, it's in and of itself, it's therapeutic. They want to have control of their own medicine. This is something they want to control. And so they should have the right to be able to do that. It's not, everyone shouldn't be obliged to go to a company. Some people don't like that at all. So let patients have control over their medicine. And there are also patients who want to have that control, but they don't have the physical means or the personal circumstances that allow them to do this. So they should be allowed to designate a caregiver or a trusted friend who could grow for them. And I see a comment on here, and cost too, and that's a fantastic point, that we know in the coming days, synthetic psilocybin will not be cheap. And so for some of modest means, they want to be able to, cost is an issue, access to healthcare, and there's other costs associated with this treatment. This issue was fought by Mr. John Conroy in the cannabis context in Allard, and John crushed the government like a grape. And as a result of John's good work, we now, cannabis, you have the right to grow it. Medical cannabis patients can grow it themselves or designate a trusted friend. And there's limits to it. It's not an unlimited right, but we wanted everybody to have the full spectrum of options. So that's our approach to what form of psilocybin you can access.
Let me interject to say that it's a lot easier, I understand, to grow mushrooms in a very small area with far less complications than there were growing cannabis and all the problems of stinking out the neighborhood and all the rest of it. You can grow mushrooms in a small area in your basement and have no impact on anybody else.
Yeah, no, that's a great point. That Jillian,
just ask a really naive question. So when you were talking about the person that should be the gatekeeper is the doctor, because they have a responsibility for the health and well-being. And you said, well, of course, that's not the government. And like, wake up, Jillian, well, what is the government's role then in our lives? Aren't they there to take care of us? Like, isn't that why we vote them in? I'm just really curious about your comment about that. Could you explain it a bit more?
Sure. I see personal medical decisions as something that's really between patient and doctor. And the doctor is so well informed, and professionally, they're directed to care only about the patient. And the government can look at the big picture, but to have, and if this was a one-off, if there was one guy somewhere in Canada who wanted access to psilocybin, and they say, okay, we got to make special arrangements for this one guy, but it's not one person. Many people are seeking this treatment. It's effective for depression, which is such a huge problem in Canada these days. So the government can't become everybody's doctor. We're not going to have bureaucrats who are we're going to seek medical advice and medical assistance from bureaucrats. They can't be our doctors. We already have great docters.
Even though that's how they're acting.
Yeah, they're saying, listen, you all come to us for medical help. We're going to be your doctors on this. And actually, I'm going to just jump into this other thing about patient-centered care, which I'm just super passionate about. Patient-centered care describes a moral philosophy with 3 core values. 1, considering patients' needs, wants, perspectives, and individual experiences. And, I think about someone who may have had psychedelic experiences previously in their life, and they're comfortable with them. And they're saying, I've heard this works. And I think for me, this is a really good fit. And a doctor says, well, I know what you're going through and I know what you've tried and I think we should try it. That's how that conversation should go. It shouldn't be, all right, well, let's start putting together the package and hopefully the minister, we can win them over and we can prove to them you've done enough other pharmaceuticals. Number two, offering patients opportunities to provide input into and participate in their care. Patients should be active in their care. We want patients saying, you know what, I've been reading about this online and I think this is for me. We want to encourage that. We don't want them sitting back idly as spectators in their own treatment. And finally, enhancing partnership and understanding in the patient-physician relationship, not the patient-physician-bureaucrat relationship. And this is shown, studies have shown that this is actually enhances healthcare and reduces healthcare costs. It's all good. It's all good.
And the history, of course, with cannabis was, Parker was growing his own. The government didn't have a supply. And so he was able to grow his own. And then they came up with the supply from the mine in Flin Flon, and that wasn't very good. And, we had to drag them kicking and screaming into coming up with the system we have now, which arguably still has many, many defects. So, historically, it's so obvious to those of us involved here how this is no different to cannabis. And we have a model with the cannabis regime with designated growers and the right to grow your own and licensed producers. I mean, really, what is the problem? I just wanted to jump in quickly too before you move to another, to just read the section or the paragraph from PHS, because these refusals of these Section 56 exemptions, I'm curious, does the government give you reasons for the refusal? And in the reasons for the refusal, do they address Section 7 of the Charter? Because Madam Justice McLaughlin, or Chief Justice McLaughlin at the time, speaking for the court, said, the discretion vested in the Minister of Health is not absolute. As with all exercises of discretion, the minister's decisions must conform to the Charter. Cites a number of cases. If the minister's decision results in an application of the Controlled Drugs and Substances Act that limits the Section 7 rights of individuals in a manner that is not in accordance with the Charter, then the minister's discretion has been exercised unconstitutionally. That's from the cases you've described that have been refused exemptions that clearly help them. And again, I'm thinking of the addicted fellow, Mr. Burke. Does the government say, oh, no, it doesn't help you? Or
I can read it out to you right now because I've got it in front of me. And it says, after careful consideration, I'm refusing your request on the basis that your physician, that you and your physician have not provided scientific evidence to demonstrate the safety and efficacy of psilocybin in the treatment of your medical condition. And that's unfortunate because the evidence that they suggested was the patient had already done it and it had already worked.
And there was no evidence of lack of safety or efficacy.
Well,
quite the opposite.
Exactly. And an absence of evidence is not evidence of some saying like that, right? If there's no evidence, you can't say that, well, you can't make a basis of criminalizing non-evidence. So it really is a fight. And I just want to kind of go back to what you were saying, John, about, the cannabis regulations that we have. We've submitted regulations. Paul's worked on regulations too. The government has at least 2 sets of regulations that would work incredibly well here to satisfy the right access for patients. And Gillian, back to your question, what is the government's role if it's not to act as a doctor? I mean, I know the regulations that we wrote, 165 pages. It's only like 1 or 2 pages that stipulate a doctor as the gatekeeper. The rest of it is all about production. It's all the stuff the government should do, which is like good manufacturing practices, advertisements to make sure it's being sold in the right places. And we can get into fights over all that stuff too. Surely none of that's perfect, but the government should take a regulating role, a governing role here. And just like Trudeau said, or his father, that is, that the government should stay out of the bedrooms. They should stay out of the damn doctor's offices too, because they clearly cannot help these patients.
And somebody asked the question, why is there so much resistance? And we used to ask that over and over and over again in terms of cannabis. And I suspect it's a similar thing where they have this stigma arising from people's use of psychedelics in the 60s and 70s or whatever. And so they, it's drug use or drug abuse. They can't overcome this attitude, from that, because where else? I mean, we don't have, as we had with cannabis, we could show historically a clear racial bias. With opiates, we can show clear racial bias against the Chinese. So, what is it about magic mushrooms that apart from that period of time in the 70s? So anyway, Paul has got another area, so let's move on to that, Paul.
Just following up on that, sometimes I've had the feeling that I think they almost like the idea of being forced by way of court case to do something that they can just shrug and say, oh, we had to because of the courts, those liberal courts. So
and I've probably talked to about a dozen members of parliament who have shared that exact same sentiment, Paul. And it's no surprise to them. It's almost as if like, duh, don't you know? It's like, they're going to want you to force them to do this because they don't want to have to take a stand and face the political risk. I mean, to them, to a minister, I don't know if anyone ever watched the show, Yes, Minister, but there was this joke in it that, if you ever heard someone say, oh, minister, that's a very courageous thing to do, that's the best way to tell the minister not to do something. Don't act courageous. That's not your role. Stability and avoid those things. And so I think that's the same thing here is what minister who only cares about votes or seemingly only cares about votes is going to do something courageous that might hurt them and their party. They will get in a lot of trouble. And again, it is a weakness of our democracy. So I think that even if, beyond the courts, which I feel I very much feel like they're going to win. We're in great hands with the two of you. We should be looking to our leaders as well and saying, this is unacceptable. Canadians should not accept a government who is going to carelessly ignore these people and just push things to the court. That's not a democracy. That's something else.
They have all these meetings saying, what can we do about the opiate crisis? We've got all these numbers greater than COVID. What can we do? What can we do? Let's have a meeting and so on. And, safe supply. I mean, we mentioned this briefly before. We've got people with the Cannabis Substitution Project in the downtown east side that seems to, people who are getting high dose edibles. It's not a legal program. They're trying to get approvals, but that's another story. But a lot of the people on withdrawal are saying this really helps them to have a high dose edible. And it's not a safe supply, it's a safe alternative, non-lethal supply, so that it's an attempt to help the person get off their addiction. And this seems to me, the evidence that you have in terms of psilocybin is way greater. Mr. Merck, his facts, I keep coming back to his facts. It's incredible how effective it was for him. And so I just do not understand how they can turn him down and say not enough evidence or anyway, I could go on. So Paul, back to you.
So in terms of the evidence that will be called, just before I go on, I want to say one more thing about the lobbying. The Psychedelic Association has done extensive lobbying and submitted a huge template on how the regulations could be. I was part of that. Therapsil, and Spencer mentioned this, submitted a huge template. There's been and Bruce Tobin's original Section 56 application was huge. And I know of a lot of other lobbying and information that's been forwarded to the government. And the government lawyers in their response said, well, if you win, we're going to need if we win, we get a declaration of invalidity. And the government is going to seek a suspension of the declaration of invalidity. And they say, we need 24 months to think about how best to regulate this, because this new problem we've got to think about. And we're saying, you know what? And we're going to call evidence about what the Psychedelic Association has done, what Therapsil has done, and what others have done. So all this amazing work that others were trying to work with the government, that's going to come back and bite them. And we're going to say, you know what, don't pretend you just learned about psilocybin yesterday. People have been telling you how to regulate this and how terrific it is and how safe it is for a long time. And I don't know what you've been doing during this time. So anyway,
let me just,
I wanted to note that. So
let me just, again, before you, because touching on that again, in PHS, the Supreme Court of
Which
Canada
is the
wasn't
Portland Hotel Society. PHS.
certainly Portland Hotel Society, which was the supervised injection site case that I read to you from McLaughlin a little earlier. Later on, dealing with this issue of the remedy and so on, the court brought up, this warrants an order in the nature of mandamus to compel the issuance. And it's extremely rare for a court to order somebody who has a discretion under a statute how they must exercise their discretion. But the court basically said the only constitutional response was to grant the application, and compelled the minister to grant the Section 56 application, and not 24 months or 12 months or any of that stuff, immediately, because of the impact on the patients, and that they needed access now at the site, not 6 months to a year from now. So hopefully you could use that in the ridiculous 24-month request. Sorry.
I have a lot more to say. I'm going to trim it down. There's two things I really want to say. So I'm going to just, I was going to go through all the evidence. We have like an illustrious roster of the, the question was, Paul, are you questioning the adequacy of the reasons? And I'm sorry, the reasons in PHS regarding the Section 56?
The refusals, I think.
Oh, the refusal, from the government on yeah, no, it's boilerplate, and they're not and as John raised, are they addressing Section 7? They're not. No, yes, I am questioning the adequacy of the reasons, but you know what? I don't want to do a bunch of judicial reviews are fine, mandamus is great, but we're going to kick the door down. We're going to just push down this house of cards, and we want to create something decent and humane. We're going to go, it's a whole lot of work, but at the end, we're going to have something good for everybody. And that's, I guess, one of the two last things I wanted to talk about. I wanted to talk about what this case is really about. These plaintiffs, they're not seeking money. There's not a request for $1 in there. What they're asking for is a new regime. And I talked about in which there's compassionate access. It's fair and it's reasonable access. And this access is, this is what I see happening. It's when I say doctor is gatekeeper, because we saw this in cannabis, that the government was very hard to get these Section 56s from the government. And then in 2001, that was when the clock expired on the Parker decision. They had 12 months to come up with a regime. On the very last day of the year, they introduced the MMAR. And that's when it was sort of a revolution in medical cannabis. And that's when many people got access. And the dam that had been building up, it started to flow. And suddenly it became a big thing, medical cannabis. And it helped many people in many ways. And
it also led to far fewer complaints by inspectors about people growing in their basements and all this sort of stuff. Once people had to get permits and everything, it solved a lot of those problems that everybody was complaining about. It's an example of the use of the law making it better instead of them driving it all underground. Sorry.
Yeah, no, when you don't have to slink around in secret, you actually can do things in a more responsible manner. So, and I believe that when we win this case and the government is forced to introduce a doctor's gatekeeper regime, they're not going to do it because they love us. They're going to do it because a judge forced them to do it. And you're going to see the floodgates will open, and many, many patients who are suffering are going to get access. It's going to be good for the whole industry. It's going to be great all the way around. It's going to be a revolution, I believe. That was the one thing I wanted to note, that this case is going to change everything. The other thing I wanted to note, and I guess this is part informing, but I also wanted to, maybe I'm seeking people who watch this webinar may be able to assist the case as well. And I was going to go through the evidence. I'm not going to go through all of it, but I'm going to focus on one aspect of it. And that's, we want to call evidence about how Section 56 and the special access program have been playing out, and clinical trials to a lesser extent, but all of those. And every time I speak to a doctor, I hear new ridiculous stories about how Spencer mentioned, I think it was Spencer mentioned the electric shock therapy and how the government, 4 patients were being held up. And then Spencer found out about it and called some called some MPs, went on the CBC, and then they changed their position. That looks terrible on the government. And every time I talk to a doctor or a patient, I learn more about how terrible this system's working. And we're calling a lot of evidence about that. We have a palliative care doctor. We've got a great pain depression doctor. We got a pharmacology expert. But I really would, if others have had issues with this, whether you're a doctor or a healthcare professional or a therapist or a patient, I'd love to hear from you about your struggles, because you can help us. And directing people to clinical trials, that's just, that's wrong for so many reasons. We don't have enough time for me to list all the reasons we say that's wrong. So it's unethical, I believe.
Or do you want me to post your email on here on our chat?
That would be terrific.
Okay,
absolutely.
I'll write that in.
You've got it, Jillian. So yes, please. And even if you contact Therapsil, they will also direct you to me. So, but yeah, please, we would like to help. We have an amazing team here. Part of this is we want to show the extent of the issue. This isn't a handful of people. We've got someone who's going to be giving evidence about the demand in the veteran community for this kind of treatment. The chronic pain depression expert is going to be talking about the extent of the problem of chronic pain and depression in Canada. It's a massive problem and it's a massive expense. So I note the time, and I think I should be wrapping up. So I'm.
You're actually good, because we've been answering questions as we've been going along, and there's not anything outstanding, I don't think, in the chat at the moment. So feel free to, if there's more stuff that you'd like to. Otherwise, we can of course go around in another discussion.
Well, I'll just have a quick note a quick review of my notes. I mentioned this briefly as well, and this is something, Section 7, and I won't get too obscure deep into the law in Section 7, but the privacy has been sort of a part of Section 7 for a number of years, and I think there's a really powerful privacy component to this case as well. And that's, this system compels patients to send very personal details to the government. And there's really a range of details, because you have to explain your involvement and what you know about psilocybin. So sometimes this involves people incriminating friends or talking about incriminating behavior they've done. Some of them may be professionals who, like for them, they have regulatory authorities who they could get in trouble with. These are subjects no one wants to talk about. And that's to say nothing of the very personal health issues that people have to talk about. And in many cases, over many, many years, and talking about different drugs and how those made them feel. This is about as personal as information gets. And we have to send it to an unknown source. You send it to the minister, and who knows who reviews it, who knows who's reviewing it. This is like a needless infringement on privacy that people should not have to do. This, again, should be between patient and doctor. We can talk about these things with our doctor. We don't want to send this information to the government, who also, by the way, as we all know, are in charge of prosecuting people for these offenses. People have asked me, well, a very good, very good point there in the box. Protects the sphere of personal autonomy involving inherently private choices. Absolutely. That language of privacy has always been sort of a part of Section 7. So I think this is really a powerful case for that privacy issue has got to be front and center. It's wrong. I have had people say, well, I don't want to talk about having broken the law before. And like, I mean, this is kind of a part of your application. This is information the government needs to know. They don't need to know any of this. I guess it's the short answer.
At the same time, if from the perspective of a criminal defense lawyer, although very semi-retired, and so I think I mentioned to Paul before, I had, over my 50 years, very, very few people charged with psilocybin cases. Often it was just they had cannabis and they also had some psilocybin. So I mean, sure, if somebody started doing a big commercial operation, I'm sure they'd jump right in. But, you know, the process would first be being caught, the police sending a report to Crown, the evidence, if it's medical, and there's what I see here in this material, I have a difficult time believing that most federal Crown would approve the charge, knowing that all of this evidence is going to come before the court as it did in Parker. And even if they did approve the charge, the court, if you are obviously guilty or plead guilty or whatever, does have the power to grant absolute and conditional discharges, which is that it's not in the public interest to enter a conviction, basically. And I'd be hard pressed to see a court wanting to punish somebody in these circumstances. And don't forget, of course, the minute you're charged, you have the Section 7 argument to argue that the section is unconstitutional. And it's not saved by Section 1 of the Charter. It's not a reasonable limit. It's the Parker argument, basically. And you have that. And you also have the necessity argument that I think I mentioned earlier. But don't forget, the necessity argument requires you to show that you're exhausting other legal remedies or trying to do it. So as long as you've applied for 56, you've tried these things, if it's necessary for your medical situation to consume something or to have something that's necessary, then the law provides that as a defense. Now, as Paul has said, last thing you want is to be in the courts with lawyers and the costs and all the rest of it. But I just want to assure people who feel compelled to do this because of their medical situation that, in my opinion, the consequences are not, you're not going to be sent to prison. Let's put it that way.
There's, okay.
Oh, go ahead, Gillian.
There's a question that we missed a little while ago, which says, well, what is missed out when the whole natural mushroom isn't used? Do you want to talk about that, Spencer? I have a reply to that if you don't.
Yeah, sure. I'll just provide the testimony of the patients who are lucky enough. Well, they're not that lucky because they're fighting here, but some of them have been fortunate enough to have access to both the mushroom and the synthetic. And I really like one of the responses from Thomas that he gave me. He said, the natural mushroom by itself, it seems to come on slower, almost as if the mushroom is welcoming you into the journey, and it lets you go, a couple hours after, just as slowly. It feels like a nicer, carry in and out. Whereas he says, the spirit of psilocybin was very much still there in the synthetic, but it was more all of a sudden, and then all of a sudden it was gone. And I think those, especially at the end, that little bit of time where the mushroom starts wearing away, you feel these other things from it. I feel like they were saying that was quite important to them. But again, that's just more on the physiological level. On a psychological level, I mean, how cool is it that the earth provides its medicine in a little mushroom that, might be growing on our front doorstep? And then, of course, too, the fact that maybe you grew that medicine yourself, and there's a tending process to that. I've heard many people who grow cannabis say that in itself has been therapeutic. You're truly helping yourself. How amazing is that? And then, of course, there's the fact of placebo, which is, if you think the mushroom is going to be better for you, it probably is. So, I mean, I think those are three very compelling arguments. But it's certainly not to say that the synthetic is ineffective. And it's not to say that all people think that way.
And don't forget, we can go back to Morgenthaler, 1988, where they had therapeutic abortion committees. And the court found in Morgenthaler that was provided an illusory defense if you were charged with procuring an abortion, that therapeutic abortion committee process was illusory and basically found it to be unconstitutional. And it was also Morgenthaler where they found that the delay in the woman being able to get the abortion, that was violating Section 7 as well. And we have that delay issue here, obviously, as well. So we mustn't forget that we've got some good origins in the Supreme Court of Canada in Morgentaler that were Parker relied upon, and certainly has been continued through. So there's some good case law that is helpful to this whole case, and I'm optimistic too.
Just
The
to go
case
back
law
to
comes
the
back to Morgentaler. Oh, sorry, Gillian.
just to go back to the synthetic versus the regular natural mushrooms. I was lucky enough to be at the MAPS conference in California in 2017, and saw a presentation by the lovely Anne Shorgan, who just passed actually this a few months ago, married to Alexander Shorgan, one of our icons in our world, and she just gave this lovely story of somebody presenting her with them at the time, the two of them, with a synthetic, and they went, okay, we're going to try it, and they actually gave the complete thumbs up and said it was a great experience for them. And so I think really, rather than debating, which is better than the other, we just really want to demand access to both and have people make their own choices. So.
Patient-centered care, as Paul was saying, right? Let them choose, let them take part in what their option is.
Yeah, well, I hadn't thought of that, Spencer. That's a great point. It's kind of part of patient-centered care is growing your own as well. I just want to comment as well. Someone had noted the Alberta regulations, and I think those Alberta regulations, someone was asking me if that matters, and I think it's really sends a signal that this is not a little blip. This is not one guy in Nunavut. Like this, lots and lots of people are seeking this treatment, and provinces are already preparing to deal with this.
Isn't there some thing happening in BC, and is it February that they're saying none of the drug laws apply or something?
Oh, that's the Section 56 that was requested by the Honourable Sheila Malcolmson, our Minister of Mental Health and Addictions. And I believe it applies now to actually all of BC, because they couldn't set any city limits. So they just said in BC, you're right, none of the drug laws apply to anyone carrying, under 2.5 grams of methamphetamine, heroin, fentanyl, cocaine. There's a couple of them, which I'll just point out.
MDMA.
And MDMA, yes.
Yeah. Nothing about psilocybin.
No.
Nothing about psilocybin. But I will point out that, in 2020, on August 17th, the Justice Department put out a memorandum to all of the Crown prosecutors saying not to pursue any charges for anybody using personal or medical
That's right. I have access. A copy of that.
So I always tell people, and I think it's true, is like de facto drugs, almost all drugs have been decriminalized in Canada since 2020. If you look at, the reporting in the US where people say, oh, this city has decriminalized drugs or that city has, they didn't necessarily pass any sweeping legislation. They just said, we're not enforcing these laws. It's what they're doing in BC. It's what they did Canada-wide back in 2020, but it presents the same issue. If that's not good enough, right? Why are these patients being forced to go to Zoomies or the mushroom dispensary, which they're certainly helpful. I've got nothing against those guys. They're providing a service for these people who would otherwise have to be picking them on the ground, which our expert Paul Stamets said is completely unsafe. So this idea that we've got to break the laws or that it's good enough to say we're not going to enforce them is lunacy. And I think it adds a lot of weight to this argument that we're making, that, you can't just stand by and be an idle government who lets people break laws. You've got to fix those laws, and you've got a positive obligation to the patients who are having to break those laws or fit in the groups of people who those new rules to prosecutors apply to. You've got to go a step beyond that and actually help them do your job as a government.
I will note that I do a lot of criminal defense work, and the drug laws are applied quite unevenly across Canada.
Oh, yeah.
And I know you guys have a marvelous little land out there on the West Coast where the drug laws don't apply, but it's a different world in Ontario, and it's a very different world in the prairies in Quebec and the Maritimes.
Oh, yeah.
It's a very good point
to that. There's a pushback to that because we've just had a sort of a law and enforcement as Vancouver Council voted in, And of course, the new premiere is all about forced treatment. Does
Well,
anyone have any evidence that that works? Anyway, so it's moving to the right.
I supported David Eby when he was a young lawyer at Pivot Legal Society.
Absolutely.
And
I think you
supported
drank
him
the
when he
Kool-Aid.
supported him to get his position at BC Civil Liberties. And so when I saw that business about possible compulsory treatment, I quickly dug up the old Heroin Treatment Act, and a big session we had with Tommy Zaz came out from New York, and a whole presentation showing them how compulsory treatment didn't work at Matsqui Institution, that used to be a compulsory drug treatment center. You know, it didn't work at Brannon Lake when they turned it into the heroin treatment center, and so that it doesn't work now. So I'm not so sure, though, that David is going that far. I've sent him those, by the way, to remind him of the situation. But you know, and again, it's a problem of the media. You hear the same story over and over again about somebody getting suddenly impulsively struck in the, you know, terrible thing, but then they keep saying it's happening more and more. I don't know if that's actually accurate. Our crime rates are actually supposedly down compared to certainly what they were 20 years ago, but nevertheless, nobody wants an impulsive, you know, reaction where somebody gets hit on the street, like we've seen some cases. And so it's more fits back into the whole problem when we had Riverview and mental health places where people were committed, and you know, we undid that, and there was supposed to be enough places in the community, houses and so on, to fill that role, and that hasn't happened. So I think the focus is more on, if you've got somebody who happens to be addicted but is acting out, how do we help them? You know, do we just leave them to be that way? A lot of it's I think a mental health issue is often the situation, but it's an extremely difficult issue. And I'm you know, I'm watching him carefully, and I'm hoping, you know, he doesn't fall for that, having to go too far. But we do have this problem. And there's somehow, I think he is trying to do something about it. I mean, homelessness, housing is one of his favorite topics. And Pivot did a big thing on that back in 2005, and he was one of the lead authors. And we need to solve that problem. And we solve that problem, we will solve many of these other problems, including the crime issue. But anyway, we've got, it's 5:17, so we've still got 10 minutes. Paul, anything further?
Well, I think I've kind of reviewed I went a little light on the evidence. I mean, we have, but I think I gave everybody a flavor of it. I mostly want to enhance it with these ridiculous experiences that people are having with the special access program. I think 56 is kind of dead, and people are, and now it's, and what I'm getting now, and John alluded to this earlier, is that they're now, because we spent the whole year or much of the year thinking this is all going to be about the special access program.
Yeah.
And there's such burdens on the doctor. The doctor has to assume liability for the whole process. And when the doctor's doing that, they probably want to know the therapist and know all the parts. They have to submit a lot of research. They got to know about the manufacturer, and they got to send all this stuff to the government. And the crazy thing is that they're now saying that we don't want to do groups. This is what they said to a doctor recently. This was touched on earlier. Well, we don't want to do programs. So a doctor with Therapsil was told she had 7 or 8 patients. And they said, no, we're going to reject all of them because this is a group or a program. We're only going to give them out to solitary applications, which really, when you think about it, the solitary doctor who gets 1 person a year who has this issue and seeks psilocybin access, that doctor is not going to go through all this stuff.
And this is such BS because, you know, they made this argument that that's not what the special access program is for programs, you know, but this is a palliative care doctor who has dozens of patients who come to her every single year with the same problem. And I have the best proof of this is if you look at those SAP forms, there's 2 forms actually. there's the first form for individual use or group use, and then there's a future use form. And that future use form there is because that SAP office recognizes that some doctors are going to find themselves in the same position as this doctor, where many of their patients are going to need access to a drug that is not accessible in Canada. And a perfect example of that might be, doctors working with pancreatic cancer patients who need access to, failed or treatments that aren't available in Canada. So they've made this form available for just such situations where they recognize a doctor's probably going to have a couple patients like this within a year. It also allows the doctor to keep that product on hand instead of having to make these applications every single time, waiting for a bureaucrat to approve them.
So we have the evidence. We don't need clinical trials, right? We've got lots of clinical trials or other trials that have been done in the past, have we not, that show how effective psilocybin is for addiction, for depression in particular. So if we've got all of that evidence, we don't need clinical trials. And if they're taking that position on special access, I mean, that seems to me, again, a total failure to appreciate Section 7 of the Charter.
Well,
and we've already gone through Section 56. So, I think if we have the evidence from the scientists about the effectiveness of this for these various types of health issues, and you have a healthcare practitioner associated to the individual patient who supports that, we have a clear ongoing Section 7 Charter violation by the government in each of these cases.
Absolutely. And there is certainly no evidence of it being as dangerous as it appears to be through the regulations that they've got right now, or these drug laws. And that's what the doctor brings up every time is, this was a political malicious decision by the Nixon administration to criminalize these drugs. It probably wasn't even psilocybin. It was probably the other. Or sorry, who was it?
I think it was probably Reagan, because it wasn't until 70,
it started with Nixon.
74, wasn't it?
Well,
yeah.
And it got worse with Reagan. It started with Nixon.
Some president from a country other than our own, right, has made these illegal, and there was no evidence. It was a political decision, and it's going to be a political decision that's going to legalize them again, because it's clearly not going to be a scientific one. If they're saying that we need to use science, that's the science is already overwhelmingly in our favor. So it's political, and the SAP process is political. And what Paul's discussing here, where they're suddenly saying no, is I believe what we call changing goalposts, and they're just going to keep changing it. And I love one of the doctors that we work with had to unfortunately get up there and talk with one of the representatives in the SAP office after 4 of his patients were being ignored for 16 days. And the person within the office is saying, oh, well, these are the guidelines. And the doctor wasn't too proud, but says, what are your credentials? The person in the office goes, well, I'm a pharmacist. And we followed the guidelines. The doctor says, well, I'm a doctor, and I actually make clinical decisions, and I'm a human being. And that's really what's missing here, is that SAP, it's never going to work because it's a politician, it's a bureaucrat, it's a gatekeeper. We need clinicians who are trained to make these decisions to be the ones making them.
Yeah, well,
I'm wondering if I can do this in our last couple minutes here. Paul and John, I would love to ask you a question that I feel like you both will be able to answer really, really great here. And it's been one of the biggest challenges that I've had. Now, I've been tasked or I've taken on this challenge of trying to get the court case funded for Paul. And we've fundraised about $75,000. And the case is likely going to cost a heck of a lot more than that. But what I think sometimes gets misconstrued is when people are donating to Therapsil, we actually cover all our costs through our operations in other ways. 100% of the donations go to Paul and his legal team, who are also working pro bono and very, very discounted too. So it's pretty much the best donation I think you could ever make to a nonprofit, considering there's no overhead and the money going to the legal team is being done at a very reasonable rate. Now, I'm trying to make clear to Canadians that there's no difference between investing in Paul and his team, investing in yourselves, because this isn't just about Therapsil. This is about a constitutional change here. This is about changing the drug laws, and the effects or the case will inevitably help any Canadian who's going to become subject to a mental health issue or death. That's kind of all of us, at some point in our lives. So I would like to hear from you too. What do you think, what would you want to tell Canadian businesses who are trying to set up clinics, trying to produce psilocybin, Canadians who want to access psilocybin? What's your message to them on why they should fund this legal challenge and why it's necessary and timely? Because you're doing amazing work for Canadians. And I think they realize it if we can communicate it to them.
John, if you don't mind, I'll jump in first.
Okay.
I spoke a lot about the patients and how this case will benefit the patients, but this is going to, for the industry, it'll change everything. Suddenly, you'll go from a tiny trickle of people who can legally access psilocybin to many people who can. This is going to dramatically change the industry. So those with psilocybin companies say, oh, it's just about those 8 plaintiffs and I don't know what they're up to, but they want something or other. What they want is to change it all across Canada. So the government's forced to change it all across Canada. And then it'll be much easier for many people to buy your product from you. This is going to change everything. And everyone's means very well and everyone's trying their best. But like if we do it on a shoestring, that won't be the same as if we do it in which it's well funded or even moderately funded. Like every bit of money really makes a difference for what we can do and change everything for the future. And by the way, they will forever look back to this case. Like going forward, this case will be a big precedent, and how the system should be is based on what the evidence we call. They're going to say, well, the judge found that actually there's got to be all types of access to psilocybin, not just one type. It's got to be between patient and doctor, and they'll have to do that because the judge will have accepted our evidence. So that's what I would say.
If you could put together a thing the way Jason Wilcox was a major player in the cannabis thing. Unfortunately, he passed away last year, but he had the Cannabis in Canada Coalition, or I forget the exact wording. And so they did often presentations online, gathering, talking about the case, talking about the issues and fundraising. And they raised a couple of $100,000 by the time we got to trial, which was very helpful because while everybody's prepared to do it pro bono and so on, there's all the expenses that arise that have to be paid. And of course, I'm sure here you'll apply for you're in federal court, so we managed to get, what do they call it, substantial indemnity costs at the end of the day because it was a public interest case. And so that should be here as well. But people must remember it costs a lot of money, not just lawyers, but transcripts, documents, experts, all these other things in order to get this to the court. And so, that's really a very important aspect of the whole thing. We want all the, what was it in that article? Microphiles, I think, are the people we want on side, not microphobes, I think were the 2 terms they used. So we got to get all the microphiles on side here and realize this is, the patient stories are the ones that I think you have to tell over and over and over again, because they are absolutely mind-blowing in terms of how there is something that really, really helps them that they're being denied by the government. Yeah. It's just ludicrous.
It is ludicrous. It's criminal. So thank you. Thank you, Spencer, for leading the fray there with Therapsil and Bruce Tobin and all the work that you're doing there. Thank you, Paul, for your many, many years of doing cases like this and just changing the world in Canada. And John, of course, thank you for being the glue in this particular conversation and in so many other ones for 50 years. It's an honor to have you tonight. And I just really appreciate the work that you're doing. And I want to thank you everybody for joining us. Happy Thanksgiving again to our American friends. And I want to just tell you that in January, I'm not sure of the date yet, we have a webinar planned to talk about the Alberta regulations and to bring key stakeholders together to talk about the strengths of it and the somewhat obvious weaknesses, which we don't have time to talk about now, but we will be talking about those in detail, and stay tuned for that and other cutting edge webinars that we bring to you, and just really good night, goodbye, and appreciate your passion. Yes.
We need the village to do this. Remember, it takes a village,
Yes,
not
it
just
does.
individuals.
It does. A village, and just, you know, we put the donation for your link onto our chat here for everybody to see, Spencer. And, you know, it doesn't take, you know, one person with $1 million. It takes many people giving small amounts, and any amount makes a difference. So please consider doing that, and make a difference in our world and many other people's worlds too. Good night.